This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, producer of these videos, and as an author. Today it's time to talk about the development of the implied covenant of good faith and fair dealing, upon which all insurance contracts issued in the United States are based. The covenant of good faith and fair dealing is a general assumption of the law of contracts that people will act in good faith and deal fairly without breaking their word. When insurers use shifty or dishonest means to avoid obligations, or deny what the other party obviously understood was a violation of the duty of good faith and fair dealing, the covenant, with regard to insurance, has therefore been implied in every contract of insurance since the beginning of modern insurance at the Lloyd's coffee shop more than 3 centuries ago. The implied duty of good faith and fair dealing is a centuries-old concept. It is aimed at ensuring that the parties to a contract do not interfere with the other party's performance or destroy the other party's reasonable expectations with respect to the benefits of the contract. Given that the duty has been in place for hundreds of years and is firmly rooted in the common law, it is unlikely that it will disappear in the near future or at all. The implied duty of good faith and fair dealing protects the ability of the parties to rely on their contract, the promises and risks undertaken, and the parties' reasonable expectations. The American Bar Association Committee on Ethics and Professional Responsibility's formal opinion number 282, issued in 1950, states, quote, "A lawyer employed and compensated by an automobile insurance company, which holds a standard contract of insurance with an insured, may with propriety defend the insured in an action brought by a third party without making any charge to the insured, prosecute an action for the insured against a third party upon a fee basis along with a subrogation action by the insurance company, or defend for a fee a person sued in a public liability and property damage action brought by a third party, when at the same time he represents the collision insurance company and the insured in a cross-action against such third party." Close quote. Therefore, insurance staff counsel ethically may undertake representation of insureds who are tort defendants as long as the lawyers inform all insureds whom they represent that the lawyers are employees of the insurance company and exercise independent, professional judgment in advising or otherwise representing the insureds. The Texas Supreme Court concluded that American Home and Travelers, 2 insurance companies, may use staff attorneys to defend claims against insureds, provided that the insurers and the insured's interest in the situation are congruent, as described in the opinion, but staff attorneys must disclose their affiliation to their clients, the insureds. An attorney working for an insurance company who represents or is instructed to represent an insured as his client or her client must consider how each party treated the other and ask, did the insurer treat the insured fairly? Did the insured fairly report facts to the insurer so it could properly evaluate the risk it was asked to take? Were both parties treated by each other fairly, so that both were in a position to enjoy the benefits of the contract? Was the insurer compelled to take a risk it did not know it was taking? Why, in the ancient British case of Carter versus Beam, did Lord Mansfield, writing the opinion, conclude that there was a covenant of good faith and fair dealing that applied to the parties to the contract? Did both parties treat the other with utmost good faith? And why was utmost good faith important? The first recognized statement of the covenant of good faith and fair dealing was issued in the British House of Lords in 1766 and written by Lord Mansfield. And the decision provided that the reason for the rule of good faith obliges parties to disclose to prevent fraud and to encourage good faith. It is adapted to such facts as vary the nature of the contract, which one privately knows and the other is ignorant of, and has no reason to suspect. Lord Mansfield was faced with the need to determine whether there was, under all the circumstances at the time the policy was underwritten, a fair representation by the insured to the underwriter, or a concealment, fraudulent if designed, or, though not designed, varying materially the object of the policy and changing the risks understood to be run. Lord Mansfield found that an ethical underwriter with knowledge of the risks being taken equal to or better than that of the person seeking insurance could not in good faith claim that material facts were concealed from him, because utmost good faith required the underwriter to use his superior knowledge to favor the insured. In Whitcomb versus Whiting, English House of Lords case of the same time of the Carter versus Beam decision, held that an admission by one joint debtor was the admission of all, and that the law raises a promise to pay when the debt is admitted to be due. It is no answer for a person insured to say that the error or suppression of a material fact was the result of mistake, accident, forgetfulness, or inadvertence. It is enough that the insurer has been misled and has thus been induced to enter into a contract which, if it had received correct and full information, the insurer would either have declined or would have accepted insurance upon different terms. Even if no fraud was intended by the person insured, it is nevertheless a fraud upon the underwriter and makes the policy void, because the insured, by not being honorable in advising the underwriter of the risk to be taken, whether intentionally or innocently, deceived the underwriter and avoided the covenant of good faith and fair dealing. By compelling an insurer deceived to enter into a contract the insurer would not have entered into. The insured, by failing to act ethically, empowers an ethical insurer to declare the policy void as a result of the deception. Ethical underwriters and claims persons should never use technicalities to reach a decision on a policy or a loss. Rather, the ethical underwriter or claims person must apply the facts to the issue raised and provide the indemnity promised. Similarly, the insured must also clearly, fairly, and completely advise the underwriter of all of the facts known or that he should know, that is material to the decision of the insurer to accept or reject the risk. The California Court of Appeal explained the decision in the 20th century as follows: an insurance company is entitled to determine for itself what risks it will accept, and therefore to know all the facts relevant to the applicant's physical condition. It has the unquestioned right to select those whom it will insure, and to rely upon him who would be insured for such information as it desires as a basis for its determination, to the end that a wise discrimination may be exercised in selecting risks. This is a 1995 decision of the California Court of Appeal called Robinson versus Occidental Life Insurance Company, and explains that the wise discrimination in selecting its risks, if it deals with an ethical insured who makes known to the insurer all the facts relevant to the risk the applicant is asking the insurer to assume, there will be no problem. Demonstrating high moral and ethical standards are vital to success in the insurance business. Insurers that have a clear vision based on ethical practices should be more successful over the long term than organizations of insurers whose personnel fail to act ethically. Ethical insurers seldom face litigation for the tort of bad faith, breach of the covenant of good faith and fair dealing, and should never see a verdict concluding the insurer breached the covenant. At most, if they dispute an obligation under a policy of insurance, the ethical insurers are compelled to pay the indemnity promised by the contract and nothing more. On the other hand, unethical insurers who breach the covenant are compelled by the tort of bad faith to pay both contract and tort damages. Ethical values in an organization like an insurer are logically connected with the success of the organization. Success follows ethical behavior because the insurer that stresses high ethical standards will also stress quality, fair and thorough claim service, and quality claim service is exactly what the insurance contract promises. The insurer that provides consistent quality insurance claim service will usually be successful over a period of time. The business of insurance cannot be graded on its success over a 3-month period. Rather, the success of an insurer is best graded upon its operation over 3 decades. The claims professional, the adjuster, may be the only contact a policyholder ever makes with its or his or her insurer. The quality of the service provided by the claims adjuster, supported by the high ethical values of the insurer, has a direct bearing on all future relationships and contact with the policyholder and all members of his extended family, friends, and co-workers. Reasonable people seeking insurance will usually be willing to pay more for honest, professional, ethical service than for promises of service that are never delivered. When a policyholder is not treated ethically in his or her presentation of a claim, he or she will tell his friends, neighbors, and relatives, and everyone with whom he is connected on social media and the insurer's customer base will shrink exponentially. Ethical behavior by an insurer and its claims personnel are the purpose for which an insurer exists, and also will allow the insurer to make a profit. This video was adapted from my book, Ethics for the Insurance Professional, 2nd edition, and is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be interesting or useful to you in your profession, please forward it to your colleagues. It's free. And please subscribe to my Rumble channel, my YouTube channel, and my blog so that you can learn about future blog posts and videos. Thank you for your attention.